All right, now let's get to our first special guest of the day. He's got lots of yummy legal advice that I'm hoping he'll enlighten us with today. Please welcome back onto the podcast, Mr. Daniel Forouzan.
Good morning, Zack. Thank you for having me again.
How are you?
Not bad. This is the craziest case I have ever seen.
Truly. Well, before we get into the Blake, I really quickly want to get your reaction to Tom Girardi's sentencing. Over 7 years, sentenced to prison. They did not give him a care facility like he was requesting. He's going into the clinker. Thoughts?
Probably deserves it. I hate to say it. It's hard to say to an old man, hey, you deserve to go to jail. But from my understanding, and it's the same thing I said last time I was here, I don't think this was his first rodeo at
No.
Ripoff Town. It really seems like he's been doing this for decades. And, is it sad that he's going to jail at this point in his life? It looks awful for an old man to stumble into jail like that. But maybe he should have gone sooner.
Yeah, I agree. I mean, he was fighting it as much as he could, but he'd ultimately lost at the end of the day. Camone, the CFO, he's going to prison too. And I think, the case at least is finally rounding out. For those that don't remember, Daniel Forouzan was the last person to interview Tom Girardi on his podcast, Schmoozin' with Forouzan, which I believe is still available on YouTube if people want to watch it. But yeah, he was the last person to interview Tom Girardi in October before Erica filed for divorce in December of 2020. So it was literally a matter of weeks from when he sat down with Daniel to give his interview to then the House of Cards came tumbling down, and since then he's been facing this legal battle. We finally had a trial. He was found guilty. He was fighting it. Now he's going to prison for 7 years and 3 months, I believe. Crazy. Let's talk Blake Lively. So obviously, this legal saga has been playing out since December of 2024. So we're now what, about 6-ish months into the not even a trial yet. We're just now getting into discovery. But so the biggest news that came out is that she is withdrawing her claims of emotional distress, both intentional and negligent. What are your thoughts on that? Obviously, she accused Baldoni of harassment, retaliation. She said that he ran a retaliatory media campaign against her, came out in the New York Times. So many other details have come out about how she was able to obtain his text messages, this Van Zan shell company lawsuit that she filed secretly and used that to obtain his text messages and then threw that in the New York Times. But so we're seeing, as we're getting deeper into discovery, she's kind of fighting giving up any sort of evidence. My understanding is it was her medical records this time that they were requesting. She didn't want to turn those over, even though she did fight for an attorney's eyes only protection of those medical records a couple months ago. So, what's your reaction to seeing her now withdraw these two claims of emotional distress?
Okay, so let's go over what actually happened here and what these allegations mean. Blake Lively files a lawsuit with several claims, one of them being NIED, another one being IIED, negligent infliction of emotional distress, along with intentional infliction of emotional distress. Now, NIED is a very specific cause of action. It applies to potentially very unique circumstances. For example, if the body of a loved one is lost by a morgue or during transit, that might be an NIED claim. An IIED claim indicates that some kind of outrageous conduct had occurred and it was so ridiculous that it inflicted emotional distress intentionally. So one is negligent infliction of emotional distress, one is intentional infliction of emotional distress. Okay, Blake Lively brings a lawsuit with these causes of action. Now, typically, you and me, Zach, and everyone listening has privileges and privacy and all sorts of stuff. The California Constitution gives you privacy. The United States Constitution gives you privacy. And between you and me, I think privacy is a good thing just from my understanding of constitutional law. However, when you bring a lawsuit and you're alleging that, hey, sir, you have intentionally and negligently caused me emotional distress, well, at that point, you open the door a bit on your privacy.
Right.
And what happened here is the attorneys served requests for production of documents as well as special interrogatories on Blake Lively saying, hey, identify all your medical providers related to these issues. And it looks like Blake Lively didn't want to do that. Now, from my understanding, there was conversation between the attorneys where Blake Lively said, "Hey, look, I will withdraw my IIED claims and my NIED claims. Let's just let this whole thing, this little, fishing expedition about my medical records, the identity of my medical providers, let's let that go. I will dismiss these claims." However, the devil's in the details. They offered to dismiss them without prejudice. Are you familiar with what I'm talking about, Zach?
Yep. We chatted about the difference between with and without prejudice yesterday because Baldoni's team, to my understanding, wanted to make sure that these claims were withdrawn or dismissed with prejudice, that she couldn't bring them forth in the future. She wanted to kind of have the option to bring these claims up, or at least, kind of leave that open should she want to explore that down the line.
Yes. In my personal opinion, if you're going to say, "Hey, look, I brought this lawsuit and we have these two claims and we are alleging X, Y, and Z," you then serve discovery to investigate those allegations. I then say, "Hey, I'm going to withdraw." Well, at that point, you probably should withdraw with prejudice because it kind of feels like a flip flop game if you don't. Now, let me be
Yeah.
clear about something. Even if it was withdrawn without prejudice, the statute of limitations would still apply. However, if we're within the statute of limitations and they dismiss without prejudice, well, 2 months later, they can bring the cause of action back again. They can amend their
Yeah.
lawsuit. Now, someone will say, "Well, Daniel, what's the big deal? They bring it, they don't bring it." Because if they remove these allegations, if they remove these causes of action, and then 2 months later they bring those causes of action back, it restarts the whole process of discovery.
Right.
So they'll have to reserve discovery, which 35 days to respond. They're going to ask for an extension. That 35 days becomes 60 days. They're going to serve discovery responses. Discovery responses are going to be garbage. Opposing counsel is going to have to meet and confer on those. Now we're 90 days in. Now maybe you get a supplemental response, which is also no good. And then you have to file a motion with the court. So I think what Baldoni's lawyers are saying, "Hey, either do it or get off the pot here. Either you
Right.
have emotional distress claims and you're willing to evidence them, or you don't." And I got to be honest with you, I'm sympathetic with Baldoni's lawyers in this case.
So, what do you think this means for her case, though? Like, is it standard for somebody? Because I was shocked, because, in my opinion, the way that the most legacy media has been covering her case, it's been more favorable to her, understandably. She, one, is positioning herself as the victim in this case, and two, she's the bigger celebrity. Her and Ryan
Mm.
Reynolds, there's more of a vested interest for them to protect their relationships, the media to protect their relationships with Blake and Ryan. Baldoni's nothing to them. He doesn't drive clicks the way that her and Reynolds would moving forward. So I understood why they favored her. They covered her more favorably. But I was surprised to see, even I believe it was Variety this week, said that this was an unusual thing for somebody in her position to do, to withdraw these claims, considering going into this she should have expected to have had to turn over those medical records regardless, especially considering she fought for her attorney's size only protection of those medical records, so Baldoni wouldn't have access to them. Obviously, if there's something relevant that would come up at trial, but it just seemed like a really strange move that, to me, in my own layman's view of it, made me think maybe she wasn't expecting it to ever get this far.
Yeah, that would suggest that, wouldn't it? Because at the end of the day, her lawyers knew and her lawyers advised her that if we are bringing claims that have emotional distress, it opens the door for investigation into your emotional distress.
Right.
After all, how do you go in front of a jury and say, "Hey, this person caused me all this emotional distress"? There's different ways of evidencing emotional distress. You could have friends and family come and explain what's going on. However, another way of doing it is showing medical records, mental health records, which are typically private and privileged. Another element that has to be understood: just because you have emotionally injured someone doesn't mean they didn't have pre existing emotional injuries as well. Think of it this way: if I go in, I get into a car accident, I say, "Hey, you screwed up my back. I want to be compensated for my back because of this car accident." The defense is going to come and say, "Okay, well, did you have any pre existing injuries to your back?" And they're going to want 10 years of pre existing medical records. When we're talking about emotional injuries, now you're talking about potentially pre existing mental health records. And
Right.
to answer your question, I have seen a lot of fuss made on the internet. Oh, she withdrew this claim. It's this and that. To be honest with you, in my opinion, not that big of a deal. IIED and NIED are sort of throwaway claims. We include them in a lot of lawsuits, but rarely are they the movers and the shakers. The sexual harassment allegations, in contrast, come with attorney fees under FEHA. And as I said before, that has aggressive teeth. So in my humble opinion, is it a big deal that they're kicking these out? Not so much, but to bring it back to your point, Zach, it does beg the question, why did they bring them in the first place?
Right. Me myself says there's no way Blake is going to be able to prove damages without the emotional distress evidence. True or false?
Well, damages are economic and non-economic. So if she has economic damages, that's one thing. If she has non-economic damages, well, that's emotional distress, pain and suffering, humiliation, anguish, anxiety, etc., etc. And can they be proven without medical records? Sure. You can have a family member come in and say, look, my husband was like this before the accident. Now, after the accident, he's a different way. I have clients who have had brain injuries and their spouses come and they say, hey, look, he can't smell the food anymore that I'm making it. The food doesn't taste the same to him now that he's had a brain injury. His personality is different. So you can evidence it that way.
Right. Now, two quick questions because we have Billy Bush that's going to be joining us in just a sec. But um, first up, amicus briefs. We've seen a number of different amicus briefs that have been filed in the last week or so. A number of organizations, other people that claim to have similar stories to Blake Lively. They are survivors or victims themselves. They're filing these amicus briefs in support of her motion to be dismissed from Baldoni's lawsuit. Is it standard? My understanding is amicus briefs are maybe more relevant during trial, but not so much during the discovery phase, and not necessarily to get dismissed from a lawsuit. Is this standard for amicus briefs to be used in this way?
It can be. It really, that's a big one in terms of it depends. At times they will come at this point. At times they will come later. In a situation like this, when we're in the discovery stage, Zach, I would agree with you. It is a little soon, but let's not kid ourselves. This is not just being done in a court of law. This is being done in the court of public opinion. So
Right.
every move by every attorney on both sides here is more than just legal strategy. It's PR strategy.
It's interesting because people have started to look in. We got I think yesterday there was an amicus brief filed from Child USA, and they're on a mission to end child abuse. And people are like, what does that have to do with justice for Blake Lively? Like, it's strange. I was joking. I was like, who's next? The American Red Cross is going to come out and file an amicus brief for Blake Lively because she's burning her career to the ground. Um, Advice. What advice would you give legally if this were your client and this is kind of playing out and you can see it publicly and you can also see, her case doesn't seem to be standing on strong foundation from what we're able to see from the outside looking in. What advice would you give to Blake Lively if this were your client?
So my clients in my office don't pay me hourly fees. I take a contingency fee from what my clients give me, what I get from my clients. So if I get my clients $1 million, I take $400,000. I only take cases if I think there's a real case there. There's a difference, however, if you're paying your lawyers hourly, which is what Blake Lively is doing. The
Right.
lawyer can tell her, Miss Lively, I don't think this is a great lawsuit. I think you're on iffy grounds. Blake says, I don't care. Here's a $35,000 retainer. Do what I say. So the attorneys must advise their clients. And look, if it's a shaky lawsuit, you can advise your client that it's shaky. But what's she going to do? She'd have to swallow a lot of pride before dismissing it. And here we're seeing a small dismissal. It's hard to say exactly what's going on behind closed doors, but I have to imagine this is anxiety inducing for all the parties.
Would you advise your client to take this all the way to trial, or would you say, hey, it's probably best we settle before things get messy? I mean, we're seeing, with the high profile nature of some of the other, people that are being dragged into this. Taylor Swift was a big conversation last week and the week or the weeks prior, and now she's kind of ditched Blake and moved on from all of this. But settlement or a trial, what do you think?
It depends on Blake Lively's stomach, how much she can take. It's ultimately the client's decision. But look, if my client had a rough case, even if she was paying me hourly, I'd be like, you do not want to put this in front of a jury if you don't have a good
Right.
case, because there's a bunch of behind the scenes stuff that we don't know about yet. It will
Yeah.
come out at the jury trial. And if the case is no good, why humiliate yourself?
Yeah. It is interesting. I mean, and the fact that she even withdrew these claims because she didn't want her medical records out, to me, I mean, I don't know. I just feel like she never expected it to really get this far. And the fact that there's more digging that's happening, I feel like they're trying to lean more into the technicalities. They're fighting very hard for this opportunity to be dismissed from Baldoni's lawsuit. To my understanding, dismissals aren't common.
No, it would be tough. You would have to file a motion for summary judgment to get yourself excluded from the lawsuit. And the standard on MSJ is very high. You have to show a judge that no reasonable juror would believe these claims, and there is no evidence that a reasonable juror could use to accept these claims. And at that point, the judge can kick it out. Now, let's say a judge kicks something out on MSJ. What's the first thing the lawyers are going to do once it's kicked out? Appeal. It goes to an appeals court, another 2 years of this and that. And then if the appeals court says, no, this shouldn't have been kicked out, it goes back to the trial court. And then the trial judge is embarrassed for dismissing it in the first place. So dismissals are not common.
Not common. And she likely won't be getting dismissed. Her, Ryan Reynolds, Leslie Sloan, the New York Times, I think they're all moving forward with this lawsuit. We're going to see it play out. We have discovery, we have depositions that are happening in July and August, and then we have trial set for March. I'm sure we'll have you back many other times to help us break down lots more of the legal drama, at least from a lawyer's perspective. Daniel, thanks for coming back on the show.
Thank you for having me.